It looks like they have you carrying insurance at the time they did this, correct?
Yeah, so they are under a Medicaid plan, a state plan.
Okay,
Um,
no, oddly enough, they have you calculated as if you're paying insurance because they're giving you a stipend for it. If you look at the, let me, I just had it. Um, yeah, if you look at the court order, it says
mhm.
support, which is $56, premium adjustment of 41, which indicates that you're the one carrying insurance, and they don't do that if it's just Medicaid. So the subtotal was 97 for 3 kids, and the ordinary medical was 59. So
How does,
that's my question. I'm sitting here going,
yeah,
that's not the way this runs.
right. So I had them insured. Well, they are still insured through my employer. So I'm
Okay,
not sure if
that's
that's
why.
why it was
That's
calculated
why.
that way.
That's why
Yeah.
they put in how much you pay, and that's what he would reimburse you for carrying the insurance that way.
Okay. Because
Mhm.
I still carry them through my employer, but I
Okay.
don't think there's any reimbursement going
Yeah,
on through
yeah.
the employer.
No, there's reimbursement going on through the child support.
Okay, so that 59 is going towards the
No,
Medicaid.
the 59 goes toward the Medicaid. The 41 goes toward what you pay for them through your employer.
Okay, so I will
Now,
probably have to
yeah,
update that.
yeah. Do you need to? Are you going to continue to carry them? Because normally you don't do Medicaid and an employer.
Yeah, so I have them covered underneath my plan because when we finalized our divorce, it stated that he was supposed to have covered them 100%, but when he
Right.
did not do so, that's when I
Well,
put them on.
and my next question is going to be this, Mr. Jackson, do you have health insurance through your employer?
No.
Okay, that would be why. I can order it to be done, but it can only be done through his employer if it's at less than 6% of the cost of his total wages. So even if we order it, we cannot enforce it by law unless those conditions are met. So it's got to be through his employer and it's got to be less than 6% of his gross wages
Okay.
for the 3 kids. So how would you like to proceed?
So I would like for them to have insurance on his end as well too, because so I just feel like
If
sorry.
his, I think the question I just asked was the pertinent one. Does he have access
Yeah.
to insurance through his employer? And if he does not, I can't make it happen.
Okay.
Mr. Jackson, are you sure you do not have access?
I'm positive.
Well, and here's what I will tell you happens, Ms. Jackson. When they checked off that box, the friend of the court automatically sent a letter to his employer to confirm or deny whether he had access. If he
Mhm.
does have access, they will bring a motion themselves.
Okay.
I have a warning set for medical issues through the front of the court.
Okay.
Okay. So if they find that he does have it, they'll be bringing that going, we're going to enforce this order. And if he
Okay.
does not, they will not bring such a motion.
Okay.
Okay. To let you know how that goes.
Okay.
So in other words, they've got this one right at this time. You're paying insurance, you are paying Medicaid. That's the way it is. They will check if he has insurance. If he does, they will force it. If he does not, they will not. And again,
Okay.
they will also confirm if it's over 6% of his gross wages, they're not going to push it either
Okay.
because that's what the statute says, and they can only follow the statute.
Okay.
So this order is correct at this time. Is there anything you'd like, anything either one of you need right now?
So there was a change in my employment, so I don't know if I probably have to go to the child
Well,
services
it
for
depends.
that.
Does that change your insurance?
Yep, my insurance
Okay.
changed as well too.
All right, I'll send it back to the front of the court. They'll just love me. No
Okay.
problem. We'll just have it re-reviewed.
Okay.
No problem at all. All we're trying to do is get it right.
Yeah, because I was just so confused. So that's really I went
Well,
down there, and this was
and,
the avenues that they guided me through.
and sometimes I spend some extra time with most people trying to explain stuff so that you understand what's going on instead of just telling you your motion's denied or granted. That doesn't help you much. If I can
Okay.
give you some legal reason as to what's happening and why, then you have an understanding about, oh, okay, that is the way it goes. So,
Okay.
okay.
Yeah,
But now
it
you
makes sense
understand.
now.
Yeah. And now you
Yeah.
understand that when you go, they're going to want your health insurance. They're going to look at you and go, you're
Hmm.
covering them and you have Medicaid? Because that's kind
Hmm.
of an unusual thing. I don't see that often. And
Yeah.
then again, they would check and see if Mr. Jackson has any form of, insurance. So, but I'll send to
Okay.
FOC because of a job change.
Okay.
And it might not change all that much in all honesty. The only reason I'm sending it is because of the health insurance, because in reality, this is based 98% on his income.
Hmm.
So it's like the child support probably won't change, but the insurance adjustment may.
Okay.
All right. Good luck. Take care.
Thank you.
Nice seeing you, Mr. Jackson. Stay safe.
Thank you, sir.
Okay. Mr. Huerta, it looks like you did connect. If you could unmute, please.
Hello. I'm sorry about that.
Really? No, there's no need to apologize. Welcome. It's one of the benefits of doing it by Zoom. You don't have to take off too much time from your job, obviously.
Yeah.
Yeah, well, that's why we've been asked to keep it this way. It's easier for the parties.
Okay.
Trying to anyway. Now, if
Yeah.
if Brenda can connect, we'll get this moving along.
Okay.
Hopefully she'll connect. I take it you're chatting with her, Miss LeVay?
That is correct.
Okay. No, I'm asking my clerk, Alejandro. She controls all this from the back.
Okay.
Let's see if we can do this the other way. Hello, Miss Villa Bravo?
Yes.
Welcome. This is the court. I'm calling you a different way. That way we have you by audio. Okay. So let's see if we can, I'll detach my head. Brenda, if you wouldn't mind saying something to confirm that my clerk can hear you.
Okay. My name is Brenda.
Okay, no
I
problem.
can hear her.
We can hear you, so we shall proceed. We are here in the matter of Huerta versus Villa Bravo. Alejandro, this is your motion. What do you care to add to it?
I just, want to spend some time with my kid. We had our first court with Honorable Alita Bryant.
I know that. And Miss Villa Bravo, were you there for that hearing?
No, I wasn't present and I never received any paperwork directly from the mail. I went to the second floor district house to ask for the results or anything like that, and nothing was given to me.
Because have you two ever lived together?
We did.
For a little bit.
And when did you separate?
In January.
In January. And this case was filed in
February, I think.
February, yes.
Yeah.
How old is the child?
He's a year and 4 months.
Okay. Because the judge did order week on, week off.
Yeah, I haven't received them at all.
I'm trying to appeal to that.
Well, that's what you're going to have to do. I am not the appeals court, but what I can do is I will send this because we have a meeting coming up soon to bring the case to a full conclusion. And I think the best way to do that is going to be to send this to the front of the court for a custody, parenting time, and child support review. At this point, due to your wages and due to your incomes, the fees have been waived in this case. So what I'm going to do is send it to them, and they're going to make a recommendation that should take care of everything. They're going to be meeting with you in 2 or 3 weeks. Mr. Huerta, you have the right to file for a show cause hearing to hold her in contempt for not complying with the previous order. Ms. Villa Bravo, you have the right to defend yourself in that same motion. Okay?
Okay.
And that would be a place where you can look at the judge.
I can't really hear you guys.
Okay. Sorry, I wish you would have said that earlier. Basically, I'm like I said, we've got a meeting coming up on July 5th. Okay.
July
I'm
5th?
going to do that meeting today, this morning, so you don't have to come again. All right.
Okay.
What I'm going to do this morning is what I'm going to do that afternoon. Let's just get it started. I'm basically going to send you to the front of the court for a full review of this matter so that they can make a recommendation, because this is a custody matter. This is not a divorce. So, and we are dealing with custody, parenting time, and child support. So I'm going to send it to them. Your fees have been waived due to your wages. So I'm going to send it to them at no cost to you. Sir, you have the right to file for a show cause for not complying with the previous order of the court. And I was telling Ms. Villa Bravo, she has the right to defend on whether that should be the appropriate order or not. But I can't choose. I am not the appeals court. The judge ordered that one. You may appeal me as a appointed referee. You may appeal my decision to the judge. To appeal the judge's decision, you have to go to the appeals court. So, okay. All righty. In any event, though, basically that's what we'll do. I'll send this to the front of the court for full custody, parenting time, and child support. And I'll leave you to your other answers on that, because she gave you a detailed enough order. I can't detail it any more than that, which is what you were asking for, Mr. Huerta, is a more detailed order. There is no more detailed order than week on, week off. Okay?
So I got a temporary...
You would have to file the appropriate paperwork to bring her into court to
confirm why she's not complying with the order. But ma'am, you should comply with
I
the
thought
order.
I did some complaints.
No,
Yeah, my
You have to-
child is not in safety. There was a shooting last Wednesday at the babysitter's house that he has for him.
Okay.
And I feel like my child is not safe with him at all. I have my reasoning.
and you have
He wasn't even
and
there.
again, this is not the hearing that's going to do that. You have to file for the show cause hearing, Mr. Huerta, and Ms. Villa Bravo. You have to defend in that hearing, and that would be a defense.
Okay, great. Okay,
Okay.
I will do so.
But I'm going to send this to the front of the court for a full review to make sure that we can bring this case to a conclusion. And I'll set it for a settlement conference sometime in about late August, okay? And hopefully we'll close this case for you and get it to final orders. Okay? Good luck to you.
Thank you. Have a nice day.
You too. Stay
Oh,
safe.
what's the question? So I wouldn't be able to see my kid at all right now, or because I
well,
still have my
because-
paperwork, which says I have.
Bottom line, this is not a show cause hearing. You didn't ask for enforcement. What you asked for was a more detailed order, which is what's before the court. You need to ask for enforcement, but you need to do so through a show cause. Now, at this point in time, if there was a shooting at your babysitter's house, she may have a legitimate reason not to give you the kid for the child's own safety. So that's going to have to be vetted out at a show cause hearing, not at a hearing asking for a more detailed order. Because again, stuff like that was not before the court. All right, good luck to you.
Thank you. Bye.
Bye.
All that theater training, my voice echoes throughout the house. Okay, so.
Morning.
Good morning.
Going.
Welcome. Good to see you.
Thank
Okay.
you.
We're here in the matter of Casul versus Dolly, and there's nothing to this. Motion granted.
Thank you.
You guys entered a stipulated
Yeah,
order.
I think. Sorry.
Yeah, you didn't
I
even
think
have
I think there was some questioning because we had originally gone to an attorney for a mediator and then
Okay.
just
All right.
decided to do it on our own. So I think
Yeah.
a judge just didn't know what was going on and wanted to
Okay.
question. And I think that's it.
No.
I do have to update
Yeah.
a little bit. My address is going to change because I'm closing on a house July 11th.
Just
and
make sure we'll get this.
that
We're
was
gonna
not,
get we're gonna get this order out to you next week. So make sure you do a forwarding address to your new address, and make sure you list in writing your address change. Okay, send it.
do you want us to do like a whole nother?
No, we'll keep it on this. That's fine.
No?
No, we'll get this
Okay.
to you. Your PO box should be fine until further order. So, right.
Okay.
And then,
Yeah,
you know,
that's what I have for mailing right now.
yeah. Put your forwarding address from the PO box to your new address, and anything sent to the PO box should be forwarded to your address.
Yes.
But you also, at the same time, don't forget to, in writing, notify the front of the court and the court that you've changed your address. Okay.
Yeah, I will do so.
Ms. Dowling, you're seeming awful quiet this morning. How you doing? Not enough coffee yet?
I'm doing good. How are you?
Okay, it's good to see you. All righty, so we'll get this entered, and of course, the law states that if the parties are in agreement on this on these issues, that the court will enter the order. That's all. Done. So
We're doing a whole lot better than what we were at the beginning of this case. So I'm very happy about that.
That's obvious. I can see it. And well, the fact that the two of you are in the same room says a lot, but thank you, and thank you for your children. They are the ones who deserve that relationship.
You're welcome.
So you have a great morning. Take care and
You're
stay
welcome.
safe. Take care. All righty. We'll enter that order. We'll get it out to you. Have a good
Thank
morning.
you. Thank you.
Bye.
Happy weekend.
You too. Yeah, if you look at the file cover on that, we met frequently
Yeah. I was
10
looking
years
for
ago.
docket entries. All right. I don't have any more match sets, so I'm just going to go through them. Just have plaintiff here.
Yeah, I actually, by the way, on the way home from the courthouse yesterday, I went to call my father.
Oh.
Yeah.
Oh. It's habits like that. It's
Yeah.
hard
Yeah, because
to.
I used to call him on the way home from court, and I call my mom on the way home from court. So
Oh. I'm sorry.
alrighty, that's okay. No, it's just, hey, part of human nature. Mr. Howard. And he's driving. And I can't even tell him to pull over.
I could chat with him, but I don't want him to read my chat. There we go.
Okay. Yeah, we only have one minor left in this case. So I was telling Miss Lipford yesterday that I was going to celebrate I wasn't going to mourn, I was going to celebrate my father's life for being the mischievous rapscallion that he was.
There we
That
go.
worked. Welcome, Mr.
Okay.
Howard. I was telling
Oh, boy.
yesterday that I was
Hello.
wasn't going to mourn, I was going to. Okay. So, well, we're going to go on the record in the matter of Howard versus Mr. Howard, were you able to pull over?
I'm pulled over now.
Thank you, God. Well, one, I don't want you recorded being in violation of the law, driving a vehicle with holding a
Right.
phone, but the other is I don't want to also record you getting into an accident.
Right.
So, but in any event, at this point in time, when was the last time you talked to Miss Howard, to Shauna?
I haven't talked to her since, let's see, Ariana graduated last month. It was about 5 or 6 weeks ago.
Okay. Because I was going to ask if you knew that she got this, but you
She
definitely
did, because I delivered it to her, and I took a video of me handing it to her personally.
Okay. All right. So she does know about this.
Mhm.
What I'm going to do is, under these circumstances, we're dealing with a 16-year-old, so I want his input. So I'm going to try and meet with him next week, and I'll reserve on giving an order.
So I gotta take another day off work again.
No, he's 16.
Yeah.
All I need to do is meet with him by Zoom, and I will issue an order afterwards. I'm leaning on the fact that I'm going to grant your motion.
Okay.
But I want to hear from him first.
Okay.
He's one of 12 factors the court reviews. I've got the factors necessary pretty much to grant you what you're asking for. However, I want his input at being 16 on this one.
And I was gonna have him come down here with me today.
That's okay. He's off school right now, right?
Yeah, he is. He's out of
All right. Does he have a job?
He doesn't, but he's gonna get one. I had to focus on getting him his license, so I just paid for his driver's training because she quit picking him up. And so,
all right. Would you mind if I met with him like Monday at 3:00?
No, I wouldn't mind at all. I mean,
and you don't have to be. Matter of fact, I don't want you to be there. I need only him. So give him this same Zoom number.
Okay.
And I will meet with him at 3:00. And I'm kind of indicating to you, unless he tells me something oddly different, I'm probably going to grant you your order, and I will draft it afterwards.
Yeah. And just so you know, she haven't. So the day of there was the day of my daughter's graduation. She haven't talked to him or called him or reached out to him since then.
I understand. That's why I'm leaning toward granting your motion. I just want to hear from him. Being 16, kind of hard to order a 16-year-old to do something they do or do not want to do.
Right.
Right.
Okay.
So, all right. So I will talk to him, and then I can make it official and issue the order on Monday afternoon.
Okay. So what do I do? Because I'll tell him that, hey, there's going to be a Zoom meeting.
Right. Just tell him to be there, set up and get here, and I'll talk with him at 3:00. All righty. Well, I will issue the order on Monday after I talk with your son.
And so, just be clear. So you're going to send like some paperwork to the house or something?
Yeah. I will send the order that I will issue. You'll get a copy of it.
And then, all right. And so, so I'll be on and make sure that, that he's online and
you don't have to take off work or anything. It's just going to be by Zoom. I'm just going to meet with him. All right.
All right. Sound good.
You take care. You've been taking good care of these two kids all along, and you got one graduated, one more to go.
Yeah, one more to go.
He's got what? 2 more years?
Yeah, 2 more years. It's been a struggle. It was actually a struggle with Ariana too, because Ariana 2 years ago they told her she wasn't going to graduate because she had missed so much school. She had been smoking weed, Sean, and vaping and all that. And then she was doing it with kids at school too. And so They put her. She had called at school, so they put her in
Well,
that Wedgwood.
okay, yeah.
She had a probation. She's on probation, and she just cracked the whip. And I mean, we just cracked the whip on her, and she got together and she graduated like a 3.2 GPA. And I mean, I was so proud of her.
You did
Yeah,
a great
so
you
proud.
did a great job with your daughter. I'm sure you're doing a great job with your son, and I
Yeah.
will issue
Oh,
after
yeah.
after I talk with him, I will issue that order on Monday.
All right, sound good. Well, we look forward to it.
Yes. Yeah, well, I look forward to seeing him graduate too.
Yes, yes.
Take care.
Trust me, we're on it. We're on
Yeah,
it.
I have
yeah.
no doubt. You take care of yourself. Get him a job for the summer.
That's mandatory. That's mandatory.
All righty.
Yeah.
Well, he's got to pay for his own dates, you know?
Exactly. If I'm tired of paying for him, that's for sure.
Yeah.
But I need to get him to the driver's training first.
Yeah.
Because I can't drive him everywhere. I'm at work, and then you have these doctor's appointments, dentist appointments. He's a type 1 diabetic, and so
Right.
he can't miss those appointments. And obviously, saying like he had to miss the last one, and now I was like, okay, I have to do something about this. So I got him signed up for driver's training. He'll start that next month, and he's going to be working. He's been riding his moped around.
You're basically confirming everything that's in the file and everything that's part of your motion, which is why your motion is more than likely going to be granted unless he throws a curveball at me on Monday. I'm not anticipating it, but okay.
Yeah.
Good luck.
Yeah. All right. Yeah. Thank you, and I appreciate it.
Thank you. I appreciate it as well. I appreciate that you've raised him well. Take care.
Yep. Bye.
Despite the mother's interference. Anyway.
Next, we can do BD versus BD.
Good morning. Mandy, if you could unmute, please.
Oh, good morning.
All righty. So we are here in the matter of Beatty versus Muhlenberg. Ma'am, I've read your motion. What's going on?
So
because you have custody of the kids, right?
No, I do not. I do not. Their father does and has since 2021 when the foster care case ended. But since that time, my time with the kids has been very inconsistent. It's went from, at first it was me getting 2 hours with them supervised by Dan and Meg, and we could go and do things. Then it went from that to me being able to do that, have them one time a month.
How long is
me not seeing them for 6 months, and then
the reason that I asked
they stopped my visits my last.
Yeah. All right. The reason that I asked the question is because there are some conflicting orders in the file, and I didn't know which order is current. So the order granting him sole custody is current because he's been drug into court for show causes for child support as recently as March. So I'm trying to figure out why he would be drug in for child support if he has the kids. So that's why my question. I was trying to figure out what the actual current situation is. Because like I said, the file's a little conflicted on what's really going on. So, so the custody order that says that he has sole legal custody and your parenting time is limited because of the Child Protective Service case is what is the current order. Correct?
Yes.
Okay. Now, when was the last time you saw the children?
April 27th.
Of what year?
2024.
Okay, so you saw them recently.
Yes.
In what capacity did you see them? Did you see them at a supervised parenting time place? Did you see them? Where did you see them?
Yeah.
Okay,
at Journeys.
At Journeys. So there is a current court order for Journeys.
The thing is that so I basically just agreed to what the judge had asked for to
close the judge asked for it to close the file in the neglect case so they would not terminate your parental rights. That's why this was all done.
Right. And
otherwise, they would have terminated your parental rights and you never would have had the ability to ask for parenting time in the future.
Yes. So I agree. They never put a solid set order and only just that it had to be supervised through a third party.
Or a third party, which is why I was asking the question, because it does not say normally there needs to be a separate order for Journeys, but if Journeys is doing something with you, they obviously have some paperwork that's not in the court file.
Oh, okay.
Child Protective Services must have generated something in that case, not in your divorce
It
case.
was just Dan, my kid's father had called them and set that up because prior to that, we were at YWCA, and prior to that, it was just Dan and Megan, his wife, supervising them.
Okay. All right. So, but you just saw them 4 weeks ago, 5 weeks ago. Now the next question would be, did they ever set up another visit at the Y? Has that stopped? What's going on with that?
Dan chose to cancel my visits at the YMCA
Why?
due to me being allowed to bring my son there, my baby son, and I guess he didn't approve of that.
Okay.
So he canceled it there and said it was because of my daughter's karate lessons, and they offered to switch it to a different day, but he said they only had Thursdays available. So then a couple months goes down the road, and then they had it set up at Journeys.
Okay. All right. See if you can continue with Journeys and make that happen. I'm going to send it to the front of the court for a full review. It doesn't mean that this is going to increase. They will look at and make sure that, say, Child Protective Services still does not have concerns. If Child Protective Services still has concerns, it may continue supervised for a while. Again, this was all done to prevent termination of your parental rights in the neglect case. So they will not let parenting time occur unless it's safe, because if he gives you the kids any way other than supervised right now, they'll remove the kids from him.
Yeah, I understand that. So my brother, it has an active relationship with the kids, with their father. They attend small group in church regularly together, and my daughters also have a very close relationship with their uncle. And I was hoping that he could be the one that supervises.
You may ask for that at the front of the court, but I am not going to order that on a Friday morning. Not when Child Protective Services has been involved, like I just told you. If I proceed incorrectly, I'll have the children in foster care by the weekend, because if I order him to do something that they have concerns over, they won't care that the court ordered it. They'll care that the concerns were not met. The reason they gave him custody was to protect the children and to prevent the termination of your parental rights.
Right.
Now, granted, that was 3 years ago, which means we're at about the time that we really need to start looking at if there's an ability to give you some normalized parenting time. The court must, if parenting time is limited, review the matter every few months to a year to see if it's appropriate to alleviate the safety measures. If it's not, the safety measures stay in place. If it is, then they will start looking at a way and method to get you normalized parenting time. But that's going to be a lot more in-depth of a discussion than just me on 5 minutes on a Friday morning. I will note that he has been notified he did not show, but we've continued with the hearing. The matter was set for a hearing at 8:30. It's now 9:09. And therefore I will send it to the front of the court for parenting time and child support, because that has not been reviewed either. Okay?
Can I please request for the supervised visits to be at the YWCA? Instead of
that, I just told you to keep following through with the YWCA. Yes.
Oh, well, the Journey, Dan.
Oh, Journeys.
Yeah.
Oh, that's right. You said Journeys.
Yeah, Dan chose to cancel those visits. Like, he stopped bringing the girls and just entirely ended those.
I'll issue an order that says visits should continue through Journeys.
Do you think that I could go back to the YWCA though, is what I was asking?
I don't know, because I don't know why you weren't at the Y in the first place.
I was, but he canceled those visits too, because I was able to bring my 8-month-old son with me, where he went to Journeys because I'm not allowed to bring any of their siblings with me.
At this point in time, your time should be with the girls in this case, not the other siblings.
Okay. Well, still at the YWCA, even if
at this point I'm keeping it the way it was. It was at Journeys. That's where it will stay. Okay. But I'll issue an order that says that the Journeys visit should continue until further order.
And then, so my hope is to establish just like a step-by-step plan for restoring my relationship.
That may or may not be possible. Like I said, that's what I'm sending this to the front of the court to review.
Okay.
Because The front of the court has the right, because they can hear hearsay, they can hear everything you want to say. They can even hear your request for your brother to have this to be the supervisor for a time
Okay.
period. They can also contact CPS, find out what Child Protective Services concerns continue to be, or if they continue to have concerns.
Okay.
That's something I cannot do.
Okay. I understand.
The court receives evidence and weighs evidence. The court does not go out and get evidence. The front of the court kind of has some ability to do that. Okay. That's why I'm sending you to them. And because of your indigent status, the fees have been waived. Okay. Good luck, ma'am. Take care. And we'll see if we can move this along. All righty. All right. We are here in the matter of Mr. Mitchell, who is with you?
I have my wife, Shalinda Mitchell.
Miss Mitchell, I'm sorry, but you can stay in the room, but I need you off screen. Just as you could be in the courtroom, but you can't be in front of me. No problem. All righty. We're here in the matter of Ward versus Mitchell. Mr. Mitchell, this is your motion. What do you care to add to it?
I just want to add that this is basically a motion for the better interest of my son, Larry. Basically, for context, me and Danielle has agreed to have him come to school here. Things haven't been the greatest in his mom's care, and there's multiple reasons for that. I'm willing to elaborate.
Well, you mentioned the fact that he hasn't been in school. How much school did he miss?
Well, technically, school from this last year, a total of 17 and a half days and 10 tardies. Which technically in Michigan, from my research,
depends on the school district.
Yeah, so
they each have their own different standards on what they will consider truant or not.
Right,
but we don't have any standardization in Michigan between the schools, unfortunately. But that's an awful lot. Miss Ward, was he ill during those times? What caused it? What type of illness?
There was many viruses going around in the school at the time. We have 2 children. Well, I have 3 children in my home, 2 of which were attending school and 1 of which was attending in a preschool. So they were passing around between strep throat, just regular viruses. I have documentation that I had taken him to the med center located near my home in Lowell. And probably even.
And what school is he in now? Or what school did he just graduate school from?
He just left school, Cherry Creek in Lowell.
Cherry Creek in Lowell. So Mr. Mitchell, you were saying that you had had him in school? Where?
He was going to Cherry Creek this last year, but our parenting time agreement was for us to each have a week on, week off.
Yeah,
the Ada Elementary.
When did she move?
She never moved. She moved to school last year. She's still at the same address.
I always lived in Lowell. We did school of choice for LJ to go to.
Okay, because the week on, week off parenting time should not be stopping one way or the other.
The week on, week off parenting time only stopped because before he finished his school year at Forest Hills Ada, I had transportation issues and also was informed that Shalinda had a change in employment, which Mr. Larry does not have a vehicle. And he works from home, so she was his transportation. She had a change of employment, and so at that point,
this has been equal time that's been ordered forever on this case.
And I did not die.
So when did it stop?
When he stopped saying that he was able to take him to school.
No.
Okay, let me more specifically ask the question. Give me a date. When did it stop?
When he started going to school in Lowell.
Okay, so that would be last fall?
Yes.
All right, sir.
And the only reason was because he said he could not do the transportation to and from school. I did not deny him any parenting time.
All right, guys. Bottom line, if she's lived at this address all this time and you've lived where you live, I'm not sure. The week on, week off parenting time was never meant to stop. What you did was choice to stop it. But you're within a year. Due to circumstances, somebody can, if they can't, like they've lost a car or they're moving, pursuant to Thoreau versus Dorr, which is a case out there that says if there's a temporary situation that creates a change in the environment for the child temporarily, the court does not change the previous court orders, as long as that change is done within a year. We're within the year. So nothing changes as to the custody. The question becomes, what school does this child go to and how does that work in the future? So week on, week off stays. Make it happen somehow. Are you going to be able to, Mr. Mitchell?
Not with him being in Lowell and her
All right.
changing.
In that case, I will send this first to the front of the court for a custody review, because if you're telling me that you can't make that happen for now, I don't know how to help you.
Not that I can't make it happen, but when he's switched from the school that we set the parenting time under, what is expected?
I don't see a court order saying what school the child was supposed to be in.
There was no order for anything. I took him off of child support and they said why. And I said, because we are basically doing 50-50 right now.
Right.
You reduced
and sir, she has sole legal and sole physical custody. She can make that decision.
That's why I'm here, because I deserve joint custody. It's not right.
Well, I understand that, but you got to understand, the child's 9 years old. This case is from 2016. A lot of those arguments should have been made up front, and they were not. So, at this point, there is no choice of school. She gets to choose the school because she's the sole legal custodian at this point.
Which I'm very willing to co-parent on.
Which is what I'm willing to send this to the front of the court to have reviewed on legal custody.
It needs to be.
Yeah. So I will send this to the front of the court for legal custody, for parenting time, and for a child support review. Then once that is all vetted out, then I'll reserve the right to have a hearing on what school. But right now, that's where she chose, because she has sole legal custody, so she has that ability to do so.
So the fact that she can't get him to school.
It doesn't sound like you can either.
I can get him to school. And me not having a car was not the determining factor of me not being able to get him to school. I've always been able to get my son to school.
But it's the determining factor now.
How?
No, it's not.
All right. I'm sending this to the front of the court for legal custody, parenting time, and child support. And at this point in time, the fees were paid on this, and looking at the income reviews, sir, that would be, there's a $300 cost, $150 each, but I'm going to, you're the requesting party, Mr. Mitchell, so you'll pay the $150 and I'll waive Ms. Ward's at this time because she's not the requesting party. So we'll get this to the front of the court. We'll see what vets out with custody and parenting time. Okay.
Thank you.
Good luck to you. So I'm granting your motion. There's no way I change custody on a Friday morning, Mr. Mitchell. Okay. So good luck to both of you, and we'll see you soon.
Thank you.
Thanks.
I can't undo in 5 minutes what you guys have been doing for a year. Interesting. All righty, next.
All right. I also have a match set for O'Meara versus Hallis Jack.
Let's see if I can find the file. Oh, there is no file on this one.
Oh gosh, I still didn't get it.
No, it's a 2012 case,
So
so
old.
it's in storage somewhere.
Oh, that's frustrating though, because I ordered that over a week ago.
Well, it takes them a while to go out to that big shed in the middle of nowhere.
All right, and they come.
Welcome to all. All right, we are here in the matter of O'Meara, formerly Halachek versus Halachek. Mr. Daney, and I read your motion. Child Protective Services is involved in Utah. Is that correct?
Yeah, it is my understanding. Yes, Your Honor.
All right, but they have not removed any of the children from Mr. Halachek in Utah.
It does not appear so.
Okay, Mr. Halachek, what's going on?
No, CPS is definitely not involved right now.
Right now, but they were involved.
CPS was called once, but the charges were dropped or whatever you want to say. They found that it didn't have any weights or any actuality to it.
When did that occur?
Last year.
Last year? What time last year?
Not exactly sure what time last year.
Why is it nobody can remember?
October.
Okay.
I think it was somewhere in September or October.
Alrighty.
When did we could get this adjourned, because I just barely got the paperwork served via USPS on the 18th. And then, of course, there was Juneteenth, and I haven't been able to get an attorney like I would.
Okay. Well, and you may need to, but right now I'm not changing anything one way or the other. So, but what I am going to do is try and I grant your motion to adjourn, but since I don't want to delay things any longer than necessary. When did you move to Utah, sir?
I've lived here since 2013.
And the children have lived there for how long?
Full time, 24/7, 365 since February 1st, 2019.
Okay, so they have lived with you for 5 years.
Yes.
What circumstances gave you the children's custody?
CPS got the children, all children that was in my ex's house removed due to verbal, emotional, and even sexual abuse.
That's kind of what I had an indication, Mr. Danian, from your filing that CPS has been involved with both parties. The reason I'm having to ask such questions, folks, is because this is a 2012 case and the file never made it to my hands because it takes them a while to order files that are so old. So I don't have any of the background, I just have the motion. Now, Mr. Halachek, Ms. O'Meara has not had any parenting time since then, correct?
Correct.
All right. Did CPS indicate to you that you are not allowed to give her parenting time?
CPS told me back then that it was not in the best interest.
Correct. But did they give you any timeline?
No, they didn't. They said indefinitely, and then if and when she did get her boys back, that she could petition the courts for some actual parenting time.
Right.
But even though she got her boys back 2.5 years later, she did not.
Well, at this point, she is petitioning the court, and the court must review parenting time. That's why I'm saying I don't know. Adjourning, it's not going to help. So the court's hands are tied. It's been a while. I just wanted to know some of the background.
It would provide me with an opportunity to actually get an attorney.
Yeah, because it's going to take the front of the court would notify you in 2 weeks or 2 to 3 weeks. They will meet with both of you, and they will issue a recommendation. During that timeline, you're more than welcome to get an attorney.
Well, Your Honor, the thing is that we need to get a UCC JEA hearing.
I'm also going to send this for child support. I'm going to send this for parenting time and child support.
Right. So we really need to have a UCC JEA.
That's what child support is.
It's
the UCC JEA hearing. If you want to trigger that, I'm sorry, you're right. I'm thinking UCSO. Too many initials. If you wish to have a UCC JEA hearing, you have to apply in Utah to open a case there, and whether Utah would keep the case or not.
I did that already.
When did you do that?
I had the previous order registered as a foreign order with Utah courts back in 2020. February.
Mr. Danian, we may no longer have jurisdiction over this case.
Okay, yeah, I was not aware of any such filing when we had filed this.
Your Honor,
yeah,
it was my understanding when that was filed that it did not change jurisdiction at all.
I don't know if it did or not. It can.
It was my understanding based on what was filed that it only allowed him to put forward motions in a Utah court, but that ultimate jurisdiction remained with Kent County.
And I'm going to have to see those orders. So bottom line, I guess, Mr. Halachek, I am going to have to adjourn on that because the UCCJA issue the Uniform Child Custody Jurisdiction Enforcement Act does require it. So it may be that at this point in time, especially 5 years later, Michigan may not have jurisdiction anymore, Ms. O'Meara. So that's going to have to be vetted out. Mr. Halachek, I would ask that you send some of any of that paperwork to Mr. Danian. You've received the paperwork, so you now have his address. I'm going to adjourn this for 4 weeks, and we're going to set it for a settlement conference where all of us can sit down with a little bit more time instead of on a motion morning. Mr. Halleck,
Excellent.
that should give you plenty of time to get an attorney. If you get an attorney, please have that attorney consult with Mr. Danian.
Okay, I will
right.
do so.
So I will adjourn.
Thank you.
Sorry,
Thank you.
my brain was on child support, Mr. Halachek. When you kept saying UCCJAE, my brain heard UCSO. So forgive
No
me.
worries.
No problem. But Miss O'Meara, that is a legitimate legal concern. So it may put a hold on things, but the courts, I'm sure in Utah too, must review parenting time every once in a while.
Well, I don't know. I just know that when that order came through, I tried to object and was told by Utah courts I could not.
And that because it's generally up to the judges on a UCCJAA issue. The judges have to confer onto which jurisdiction will be the correct jurisdiction to continue.
Okay. And I have no idea if any of
And
that.
I don't know if they did that. And the judge that was in place at that time had to retire due to age. We had a new judge for 2 years after that. And then we now have another new judge. So we are now on their third judge in, all appropriately done, but I don't know which judge did what. So that's up to them. Okay.
Okay.
Very good.
The benefits of being an appointed referee instead of an elected judge. There's some things that above my pay grade.
Thank you very much, Your Honor.
Take care, everyone. Thank you
you.
all, and we'll get this moving along because eventually she's going to get to see the kids somehow. And it may be that you have to travel to Utah, Miss O'Meara. All right.
If that's what it takes. I do know,
Yeah.
I don't know if this affects it, but our last order did automatically open for visitation. I just never petitioned the court due to funds.
Right. And so that you understand, Mr. Danian, this should be with Judge West, not Judge Bryant.
Okay, I'll make a note of that.
Okay.
All right.
All righty.
Thank you.
Good luck, everybody.
Thank
Sorry
you.
I couldn't be of much assistance, but at least we've got some direction to go now. Take care. And get that paperwork, Mr. Halachek, to Mr. Danian so he can review it. And then if you get an attorney, have them confer. Thank
Yes,
you.
Your Honor.
Take care. Have a good morning, everybody.
Thank
Mr.
you as well.
Tompkins, you did review page 2. It is the correct page 2.
It is the correct page 2, yes.
All right, so we'll get that entered. The only thing the question I have is I have a feeling somebody sent this as a double-sided copy and the court only uses single-sided. So what probably happened, it was on the back page of the one and never got entered that way.
That's exactly what I think because it was on the back side of the
Right.
divorce agreement, which was a
Yep.
single-sided document.
And when they copy it, they only copy the one side because the way the court files are designed, they are attached at the top. So if you do double-sided and you try and flip over and try and read the back side, you can't. That's why we
Yep.
do single-sided. It's just easier to read. So motion granted, I will get that order entered.
Okay.
I just wanted to
Thank you.
confirm from both of you that it was the correct page 2. Alrighty.
It is.
Nice to see both of you. You stay safe and have a great afternoon and have a great weekend.
Thank you. You too.
Take care.
All right. Bye.
Alrighty. Miss Nordland, welcome. We brought you in first because we wanted to ask you if Miss Oland or Miss Tompkins now is representing you still.
She is not.
She is not. That's why we wanted to bring you in because we have everybody here but her. So we didn't want to hold you. Yeah, we didn't want to hold you in the waiting room until your attorney showed if your attorney's not coming.
Thank you. I appreciate that.
No problem. Amanda, welcome to the fun. Mr. Nordland, did you connect?
Working on it, Your Honor. It looks like
Okay, you got it. See, you're there. You not only worked on it, you succeeded.
excellent.
Alrighty. We are here in the matter of Nordland versus Nordland. And Mr. and Mrs. Nord are parties. I invited the Kent County front of the court because the order that you're asking to enforce, Mr. Nordland, is done on a specific track that this court has no involvement with. It was done at a show cause hearing that the front of the court does every Wednesday, and they do like 100 to 150 of them in the morning and 100 to 150 of them in the afternoon. And they make special arrangements during those motions. And we have a visiting judge come in to handle them because there are so many. That takes it off the track of all the normal elected judges. And the referees used to handle them, and it became too much for even us. So we bring in a visiting judge. So that means I have no knowledge about what agreement was made, basically. So that's why I invited the Kent County front of the court, who was present. It's my understanding that it was not it was Miss Lipford that was present, not Miss Schenkel. So, and both of them are attorneys. So, but
Oh.
you would know one name over the other, so don't worry about it.
It was,
Yeah.
I actually attached the order from.
Right, right. Now I'm
And
going to
neither of
ask the
those
front of
names
the
are
court for
familiar.
input. Okay, Ms. Remick, you reviewed this motion.
Yes, I did, Your Honor. So I was not present that day either, and that's not really my wheelhouse, but it was my understanding that there was a can you hear me okay? Okay. My understanding that there was a stipulated order entered to give parties time to submit the documentation that was being referred to at that hearing. So if I'm understanding correctly, Mr. Nordland had said that he paid for part of the medical expenses that were in the balance being collected at that court hearing. So they gave him time to provide the documents. I think he was also anticipating that Ms. Nordland would submit something, which I'm not sure what she was supposed to submit. But from the front of the court's perspective, we have sent copies of everything to Mr. Nordland when Ms. Nordland submits reimbursements for medical expenses. And if we had a medical objection hearing about a month ago where we didn't have the proof from Mr. Nordland at that hearing, so you ordered him to pay our balance in full. And we actually gave him an adjustment for the credit card payments that he is alleging and was talking about at that court hearing. I don't know if that provides clarification or not.
Can't hear you, Your Honor.
Free, you're muted somehow.
Great, me and my
go.
big fat elbow. I hate these fobs, which are right at your elbow
Yeah.
level. Yeah, at one point in time, Ms. Remick, I set it down to 0, so I could not hear you for a second, but I was able
I'm
to
so
catch on.
sorry.
No, that's my fault, because like I said, my big fat elbow hit this. But in any event, so it sounds like we've dealt with all that issue, Mr. Nordland. Sounds like everything's been done.
No, if you read my motion, Your Honor.
I've read your motion, and your motion doesn't make any sense. Basically, you were given credit for things. You were sent for a show cause hearing. You did not turn over the information according to the front of the court that they had requested of you.
I had 30 days and I submitted that within 30 days.
According to them, you have not.
So when you were talking about the tax intercept, so you had a medical reimbursement balance on the account prior to our last medical objection hearing that we had about a month ago, which was, I believe, $443. I don't have that figure in front of me.
That sounds familiar now that you say that. Yeah.
So there was a balance, and that's what that show cause hearing was about, not the $191 that was added on after we saw referee Kmetz at the objection hearing. So they're kind of two separate issues.
Right. Okay. Could I speak? That was,
yeah.
The hearing wasn't a month ago. It was actually March 11th, the last time we all spoke.
Okay.
And the amount, the hearing, the contempt hearing was for $443.48. If you read the back page of which I included as Exhibit A, adjourned parties to provide proof of medical expenses and payments within 30 days.
Correct.
Which I did. And that was a total.
Hold on, Ms. Remick, did he provide that? Because I was told by the front of the court on the email when I asked for you that he had not.
Okay, so there's two things going on. So he was to provide credit card receipts. They set aside that hearing because he didn't provide what he needed. He provided them to me after our hearing, which I do stand corrected was in March. So the show cause hearing happened prior to that. So he submitted proof of what he paid for credit card payments. It was not related to the balance that was already on the account at that hearing. The credit card adjustments came with the later medical reimbursement that was kind of ongoing with Miss Nordland at the time. So the balance at the show cause hearing, there was some discrepancy and they set it aside to give parties time to submit proof. I wasn't at that hearing to know what proof they were supposed to provide, but Mr. Nordland did provide credit card receipts to me after the March 11 hearing, and we did make the adjustments for that.
So you made the adjustments, so he did give that timely, and then you made the adjustment.
We made the adjustments for the credit card payments.
So he did not. So he did not owe the 443. He owed the 443 less the credit card.
No, he owed the 443, but with the 191 that we heard at that hearing in March, that's what the adjustment was made. So the parties have up to 1 year from the date of service to submit bills. So the show cause hearing balance was correct at that time, but he was saying that he had receipts for the medical, so they let him submit those, and they didn't ask him to pay anything that day, but it was found that that balance was true and owing. And then when we had the hearing in March, he didn't have the proof at the hearing, so you ordered the full 191 to be added, And then a few hours after the hearing, he provided me the proof, so I removed those charges. And so there was less added on after that hearing. So we did just complete an audit and the results were sent to both parties. So I'm confident in the balance that's owed on the case at this time. Both the parties should have received those.
Have you received the audit, Mr. Nordland?
There wasn't actually an audit of showing the balance that I had already paid. The amount that I paid, that I had copies of not only credit card receipts, but actual provider bills, were 4 different bills for a total of $169.66, which should have reduced my $443.48 by $35.12. That never happened, and the money was taken from my state income tax refund for a total of $443. And never once have I been shown the information that Ms. Nordland was required on the objection, on the.
What was she?
All right,
it says clearly expenses and payments within 30 days from both parties.
Ms. Remick, you weren't. All right, I'm going to have somebody from the front of the court explain this a little bit more, go over that audit. So I'm going to give a settlement conference for half an hour in the next month or so, and we're going to review that. But review that audit. I'd like a copy of the audit too, please.
Okay. Who would you like at that settlement conference? The person conducting the audit?
Whoever can explain it to me.
Okay.
It may be you, and it may be somebody else.
Okay, because I didn't do the audit, so I guess I'll just try to provide a quick summary. We can definitely do that, but essentially, the order to show cause hearing that balance had already been added from previous medical reimbursements. So
I think you've got it right. I just want to confirm you've got it right.
Okay. We can get a copy of the.
I'm like 98% sure you've got it right.
Okay. Yeah. Okay. Well, I will look into who completed the audit and who's the representative that would be at that hearing, because that's not my wheelhouse either. But I did request.
I need somebody whose wheelhouse it is, basically.
Okay. Yep. Okay.
Because I'm tired of the round robin on this one. There always seems to be some little nook, some little cranny that seems to edge itself in, and we are spending much more time, money, effort, and energy than $160 is worth. But bottom line, I still get it done right. So I'm 98% sure you got it, but I need somebody who can't sit there and tell me this isn't my wheelhouse.
Okay. Well, I am prepared with the figures, but I can't go over the audit line for line. So if that's what you want, we will need somebody else. But as far as
line for line, just to make sure that the audit is complete and done. And Mr. Nordland, I have a feeling it's done correct. I suggest you look at it very
audit
carefully.
Is complete and done. The numbers are correct. So I'm just saying that.
And what would happen with any tax intercept is they adjust. If there is anything left over, they send you back the excess. If there is not, they apply it to an arrearage.
Yeah, well, what happened was that the case would have been submitted for tax offset with the balance that was at the show cause hearing of the 443. And then after the March hearing, the new balance was added, the 169, and then it never updated. So we did not receive payment in full for the balance of the case from that payment because it was the previous balance owed.
So in other words, it was going to get swallowed up one way or the other.
Yeah, he still owes additionally. We've made the adjustments and he still owes the balance on the case. There's nothing to be refunded.
So I think somebody from the front of the court sent me when they said you were coming. They sent me a balance. I think there's a $613 arrears anyway.
There was, and then we received that payment that he's referring to. So now
443 should be wiped out of that because it came out.
Okay, so then it's down to whatever. All right.
Well, but there's not the $35.12 never showed up anywhere in any credits. So I look forward to the next hearing where this can be explained to me because it makes no sense to me. I'm so confused, Your Honor.
Yeah. Ms. Remick, is there a $35 somewhere coming in the pipeline? What's going on?
Okay, so the balance at the end of March was after we added the 170.14 from the previous hearing. So we met in March and we had the hearing. Mr. Nordland didn't have the credit card receipts. He submitted them 3 or 4 hours later. I made the adjustments. So instead of the $191 figure that you ordered at the hearing, we added an additional 170.14. So after we received the payment that Mr. Nordland's referring to, the balance today is 170.62. So the receipts that he provided payment for he actually overpaid at the provider and then he received a credit card refund back. So we only credited him his portion of what Miss Nordland was reimbursed for. So the numbers are correct. That's why I requested the audit.
Okay, in that case, that's all been taken care of, Mr. Nordland.
No, none of that shows up anywhere, Your Honor.
She just explained where it shows up. We're done. Motion denied.
Okay.
We're moving on. Have
Then
a good
can
morning.
we clarify from the March 11th?
No, I'm clarified enough. We're done.
Isn't the plaintiff supposed to pay bills? So this
Plaintiff
actually
was
goes
paying
with-
bills. You just told her, she just informed you that you only reimbursed for what she actually paid. So she had to show them that she actually paid it. That was done. We're done. I'm not arguing over $35. Have a good day.
And
good luck. Bye. Thank you, Ms. Remick.
Thank you.
I've read your motion. Mr. Rutkowski is not here. This matter was set for hearing at 9:30. It's now 9:49. He's been giving well enough time to show up. At this point in time, Ms. Ridgway, I'd like to tell you that you already have custody.
See, when I had enrolled Auburn into school, though, he was popping up on her Michigan paperwork, and I had asked them to remove him from that, and they said that he had parental rights, and unless
He does
they had
have parental, he does have parental right, and I cannot terminate that. He has the right to be involved with the school. He also has the right to be involved with the doctors, even though you have sole legal and sole physical custody.
But they were saying they couldn't stop him from picking her up. If he wanted to pick her up, he could pick her up and take her.
He doesn't have any parenting time.
We've never established anything.
Right. That's what I mean. He doesn't have anything. It's by agreement only. The only parenting time he has is if you agree. If you do not agree, he has no parenting time.
When I enroll her into school this year, if I am having the same problem, what am I supposed to do?
Well, what I will do is I will issue you an order that grants you officially and in a separate paperwork sole legal and sole physical custody. That parenting time is by agreement only if the parents agree. If they do not agree, there is no parenting time. He may not pick the child up without mother's permission. How's that?
That sounds good.
All right, hold on. Let me write it down. But yeah, by statute, you have sole legal custody.
Okay.
By court order, you already have physical custody.
Okay.
So, and there has been no court order granting him any parenting time other than what you agree to.
Okay.
So you can only pick up child from school. Does he see the child at all? Alexis, does he see the child? Does he see the child at all?
No, he hasn't seen her since last fall, probably in October.
Okay. So he's never tried to pick the child up from school.
No.
Okay.
But
so this isn't something that's been threatened or said that that's going to happen or.
No,
Yeah,
but he is manic, and he was very manic last year, so I had to get a restraining order on him because he kept showing up at my house. So that was one thing I was concerned about, was him finding out where she went to school and picking her up.
No problem. What I would indicate to you is that it sounds like this is just a safety measure, but they have to put him on paperwork and stuff because he is the legal father. He has no legal rights other than being a father, but under statutes in the state of Michigan, even if you don't have any legal custody, if you're a legal parent, you have the right to access the school and talk with the school and get the school records. You also have the right to talk with any medical personnel or professional that is treating the child. That doesn't mean you get to make any medical decisions. It also does not mean you get to make any school decisions. In other words, you have the right to have knowledge.
Okay.
Okay, that's what he has.
All right.
And that the school can't stop without court order. And the court order would not override that unless he is effectively interfering. So if he actually starts interfering with the school, then you file a motion and I will limit contact. But I need evidence that he's actually doing some actual interference with the school or the doctors. Okay. If he shows up at the doctor's office and makes a scene, great. We'll stop him from doing that. If he shows up at the school and makes a scene or actually shows up to the school to try and pick up the child and he causes a scene, maybe at that time I'll issue an order, no contact with the school. But I need something that he's actually done to prevent that. Otherwise, the statute's pretty clear. Every parent has the right to know what's going on with their kid.
Okay.
All righty. Any other questions, Ms. Ridgway?
No, thank you.
In that case, I'll issue that order confirming what you already have.
All right. Sounds good. Thank you.
That way it's in plainer English and the school might understand. The state of Michigan was not brought by either party. We had adjourned to allow for the Mr. Mercado to send a pay stub into Ms. DeHaan for her to review. Ms. DeHaan, has that happened?
It has, Your Honor.
And how close were we to getting the pay correct?
fairly close. So it's my understanding that Mr. Brocato earns $19.05 an hour. I only had one pay stub from him, so I can't ascertain the exact amount of hours he works typically per week. I do believe, though, that my calculation was previously quite accurate. Thus, I did submit the same documentation for entry. However, I did try to reach out to Mr. Brocato. We had touched base initially, but I was unable to give him my full attention at the time that he had talked. I tried to call back. He was busy. I hadn't heard back. So I thought this would be the better platform to work out these details. From the pay stub, it seems that he pays $10.62 in dental and $17.31 in medical for insurance purposes for both of those sums. I was unsure, as the pay stub was unclear, as to whether those sums were pertaining to both himself and the minor child in this case, or just the minor child. So, Your Honor, with the documentation.
Well, let's ask the question, Ms. Brocato. Is that just your insurance for you, or are the children covered under that?
Both. That's Blue Cross Blue Shield for both of us. I cover her dental and medical. The dental covered $2,500 for braces, or $2,000.
Okay, Mr. Hurk, is that your understanding? So you have the medical, and that's part of it.
I have the dental. I don't have a medical card yet.
Okay, but get that medical card to her so that she can use that too. Sound like the dental came in handy. Sound like the dental came in pretty handy. I don't know many. I don't know.
There is dental. There is dental. I can.
No, but I mean, I don't know many dentals that cover braces. So congratulations.
Yeah, mine did $3,000. So we're both set on that. So that's good.
Okay,
but I don't have a medical card yet.
Okay, get the medical card to her, sir, so she can use it.
Not a problem.
Mr. Hahn, and it's only the two of you, Mr. Brocato, that are covered, you and your daughter?
That is it. Nobody else.
Okay. All right. So because what we do is you get credit for a percentage of what you pay for on your daughter's behalf.
Gotcha.
Okay. So in other words, it's divided in half, and then the program divides it out by. Mr. Hahn, did you run it? Did you run it that way by chance?
I did run it that way. The overall child support amount is $394, Your Honor. $408 in base support. An adjustment of credit for Mr. Brocato of $32, yielding a subtotal of $376, and $18 in ordinary medical, which I did confirm through DHHS that Ms. Uharic, if I'm pronouncing your name incorrectly, I apologize greatly, is still currently receiving Medicaid and food assistance, so that $18 would go to the state of Michigan to cover the Medicaid for a grand total of $394 in total, and then minus the 18 later down the line for that. There was an amount also listed as garnishment on Mr. Brocato's pay stub, which also was unclear as to what that garnishment was.
Doesn't matter. We go with the gross income. So
yeah, it's a court fine from previous years ago. Yep.
Yeah. So in other words, no big deal as long as it's not child support that was already being garnished.
No, it's not.
So, okay. Yeah. So because that's why we only plug in the gross income, because the program itself takes out all the actual taxes you pay.
Right. I have it set up to take out of my account, my work account, so it's taken care
the
of.
front of the court will do that as well with the child support. They'll contact your employer and they'll set it up to be drawn out of your check.
Okay. Is there a date I can expect this to start? Do you have any idea?
It's going to take about 3 weeks. So the paperwork's got to be processed. They got to generate the court orders to send it to your employer.
I know it said something in the paperwork I got in the mail. It said effective 10/1 or something like that.
Right. It goes back to the date of filing. That's why that's why the adjournment didn't matter, because the date of start is preserved.
Mm-hmm.
The state preserved that when they filed the case.
Mm-hmm.
Okay.
Yep.
All right. Any other questions, Mr. Brocato?
I have just one last question. We can wrap it up. So basically, this is coming from the state, basically, because she was on state aid, correct?
Correct.
Okay, I got it.
As I said, neither one of you brought this case. No, neither one of you asked for this. Neither one of you wanted this. The state mandates it.
Right. And if
I generally have to, I generally
Right.
have to, I generally
Sorry
have to,
about
I generally have to explain that to people because they want to blame each other for bringing the case. And it's like, you guys had nothing to do with this. The state mandates this by law.
Right. And if she wasn't on state aid, it could have been amended, or it can be amended at a later date.
If there's no state aid at all whatsoever, I'd love to stay out of your lives.
Can it be amended in the future?
Yes, it's always amended. I mean,
Okay.
until the kid turns 18 and is out of high school. All right, I lose jurisdiction of custody and parenting time when the child turns 18. I lose jurisdiction of child support once they're 18 and out of high school. The only thing that we maintain after that is any arrearage that's owed.
Right. And it's
So, yeah, it's
she'd have to be off. She'd have to be off the food stamps
Right, she'd have
and
to be off.
the medical.
She'd have to be off everything.
What's that?
She'd have to be off everything.
Well, hold on 1 second.
All right, no. We're not playing that game. You don't get to play with somebody else on the sidelines. I'm sorry, Ms. Uharic. Is there anything that you'd like to add?
Well, I guess I'm just wondering, like, so after that, then the $18. So basically, he's only paying $18.
It depends on what kind of state aid you have, which is why I can't tell you, because the state makes that determination through another process. Because I don't know, nor will I ask what state aid you are on.
Okay.
All right. Generally, one of the state aids triggers this. Doesn't matter what it is, any one of them, and they can confiscate just the 18, or they can confiscate all of it, depending upon what state aid you're on.
Okay.
So you may get nothing. Depends on what other state aid you're on.
Okay.
Because the state may confiscate any or all of it.
Okay.
And I've had that happen where the party begged me not to put in the new order because she was going to get less because of it. And I'm like, there's nothing I can do. It's set by law.
Right.
Because they were going to adjust her state aid and it was going to go down, and then the child support was mostly confiscated and she wasn't getting as much, and there's not a darn thing I can do. It's set by law.
Right.
Okay. All righty. And again, neither one of you brought this in. All righty. So I'm gonna grant the state's motion. Good luck to both of you. Take
Your
care.
Honor, for a matter of housekeeping before the parties leave, will it be permissible for me to amend the documentation to reflect that we had a hearing rather than a default?
Yes, yes.
Would it be appropriate for me to remove the language in paragraph 12 of the child support order, which states that due to defendant's non-participation in the establishment?
Yes, please do. He
I'll remove
participated.
that.
Yeah, he
and
participated.
I prefer that I send this via 7-day due to all these changes.
No, just go ahead and do it by DocuSign. We've made the changes on the record. And
Thank
you
you,
can
Your
know what
Honor.
those changes are. That way we get it started, and that way there's no more delay.
Thank you, Your Honor. I'll have those
All right.
changes and get and also the judgment will reflect the new amounts and all these things. And
Correct. Yeah, that's placed on the record. Have a good morning, everybody. Stay safe. It was nice to
Thank
see you
you.
again.
Thank you.
Take care. Glad I could try and explain it as best I could. It ain't good
Thank
one
you.
way or the other. It ain't good one way or the other, but you know, it is what it is. So
Thank you. Have a great day.
You too. Take care, everybody. All right. Do we have any other match sets for Mr. Hahn?
Not match such, but I have defendant here for Elder versus Eaglehoff.
Oh, he's here.
He's here.
That's
Is there
great.
something I should know between the two of you?
No, I didn't think he was going to come. I'm very
All right.
excited to hear it here.
You both sound like you knew something I didn't.
Not me. I don't know anything.
That's my job. I just have to know the law and apply it when it's before me. Everything else I don't know. All right. I guess Mr. Hahn, we'll go with that one then. It's 20 minutes later, so we've given everybody their 15 minutes. Mr. Egelhoff, if you care to unmute, please.
I have no idea how.
Oh, you just did.
Oh, okay, cool.
See? You knew what you were doing.
No, I have no idea.
Just pretend you know what you're doing. You know what you're doing. Come on, you can do this. Fake it till you make it, man. Fake it till you make it. All righty. All right. We are on the record in the matter of Elder versus Egelhoff, case number S. I will note that Ashley Elder is not present. This matter was set for hearing at 10:30. It's now 10:52. We do have the defendant, Mr. Egelhoff, here to explain to you, sir. We are here by a motion from the state of Michigan. We are not here. Neither party asked for this case. The state of Michigan mandated this case because state aid is involved. So the state of Michigan is represented by Mr. Hahn through the Kent County Prosecutor's Office. The state of Michigan, this is to preserve the state aid that's involved in the case, and the state will confiscate part of the child support order to reimburse the state for what they're paying on behalf of the child. So the mother may or may not receive any or all of this. There's part of it's going to be confiscated one way or the other. I don't know what part. That's the problem. Okay. All righty. So I will let Mr. Hahn proceed on her motion from the state of Michigan, then we'll go with any questions you may have. All right. Mr. Hahn, if you care to proceed.
Thank you, Your Honor. Good morning. This case was filed on January 19th, and service was proper on the defendant on April 8th. Did not receive a response from the defendant in this matter. As such, the case was presented to me for default.
Okay.
In review of the documentation and review of my file, it was presented to our office that the parties were in fact married.
Okay.
As such, we had filed a complaint for 3 children that were born. We had 2 under wedlock. 1 had an affidavit of parentage in California.
Okay.
I called the plaintiff as I was reviewing the file, and we did not have a marriage license in the file, but based on information she provided to my caseworker, we were 98% certain that the parties were actually married. When I reached out to her on May 30th to inquire as to where the marriage license was, because she had again informed my caseworker that she was working on providing that information, she informed me that the parties were actually not married. Now,
well, hold on. So stop there. Mr. Egelhoff, can you confirm or deny whether you ever said I do with this person?
I can confirm that we did try to get married, and
did try.
When we were having the ceremony and everything, the pastor who did the marriage made a mistake on the certificate, so the certificate was voided.
So there is no legal marriage at this point.
There is no legal marriage.
Okay. Thank you for clearing that up.
I would like to also add, I did respond to the office when I got the paperwork. I faxed it to the office.
Our office did not receive that, but I'm very pleased that you are here to let us know.
Yeah, I'm glad you're here for the input. So, but I only have 1 child listed in this.
Correct.
So that's where we're getting to?
That's where we're getting to, Your Honor.
Okay.
In the complaint, there are 3 children listed. Now, if I can direct your attention to the first page of the judgment of support in the other paragraph, I did state that the judgment of support and uniform child support order does not pertain to the children MNE, and I'm using their initials for confidentiality, and LJE. It has come to light that paternity for these 2 minor children has not been established. As such, the complaint for support for those 2 children I just mentioned is dismissed. As such, the complaint for support filed by the state of Michigan shall pertain only to the minor child KRE.
Okay.
So
Mr. Egelhoff, are the other 2 children yours as well? Do you know?
So I honestly don't know.
Okay. Well, in that case, that's going to have to be a separate case where you can argue for DNA tests and stuff.
Okay.
You signed up for this one. You signed the affidavit on this one, so we know that you are the legal father for this one because of what you signed. Okay.
Right. As far as I know, I have no 100% cannot say yes or no.
So it's a definite maybe.
It could be a maybe, yes. She cheated, she lied. There's a reason why we separated. And my current situation was because I was homeless.
Okay.
And I had to leave the area that I was in to get off the streets.
Okay. What general area are you living? I don't need to know the address, but
in Needles, California.
So you're living in California. Okay.
Yes, I'm currently trying to get out of California.
Okay. Keep the front of the court in Kent County informed in writing of any address changes, please.
I will.
Because I don't want to have any future hearings without you knowing about them. And
correct.
That may be the only way we get a hold of you. So please keep them in writing to the front of the court at Kent County.
Okay, I will try to.
Right. What type of work do you do right now?
I'm a delivery driver.
Okay, how much do you earn?
Anywhere between 30 and 40 hours, depending on what the orders are,
and how much do you earn per hour?
Minimum wage in California.
Which is what?
$17 an hour.
Oh, nice. Okay.
Your Honor,
they're arguing for 30 here. I mean, they're arguing for 15 here. So,
if I may interject, I did a little bit of research prior to submitting my documentation. I did impute him as we did not know if Mr. Egelhoff was working. And I don't live in California. I'm in Michigan, obviously. My understanding is that minimum wage in California is $16, so I did impute him to $16 at 35 hours a week.
Okay, so we got your income about right where it's at. That's what I was double checking, because we do have your income pretty accurate then. So, okay. Next question. So we got one child, definitively. The two others are questionable. That'll have to be another case. Mr. Egelhoff, do you have any other questions? This comes out to be about, if I do the math correctly, give me a second. This comes out to be about $106 a week for the one child.
So,
using your current income.
So $200
give or take. Yeah, give or take. Because you get 26 checks a year, not 24. So it's good. The division is weird.
My only problem is due to my bills.
Yeah,
it's going to be really hard for me to be able to afford.
I know, but unfortunately, Michigan law does not allow me to take into account your bills. If I had to take into account your bills, I'd have to take into account the bills that it's actually cost to take care of the child, and you'd pay a lot more if we had to do that. So that's why Michigan law ties my hands that I can't look at that.
Okay.
All righty.
So how do I supplement the money in order to survive out here?
I don't know. I mean, child support is set by law in the state of Michigan. At this point, because she's on state aid in the state of Michigan, the state demands and mandates that we set child support by law. And we've got your income right where you're at. And
it's funny too, because this is the first time I've heard from her in 8 years.
You haven't heard from her at all.
No, she's blocked me on Facebook.
No. I mean, you haven't even heard from her now. This is the state of Michigan bringing the case, not her.
Oh, I understand.
She didn't ask for this. That's probably why she's not here. She had the only thing that's involved here for her is to maintain her state aid. That's it. That's the only reason we're here. So she didn't ask for this either. Matter of fact, we have some people that call and say, "Would you please stop this?" And we can't. As long as state aid's involved. If state aid is ever stopped, I don't have a dog in this fight. You guys, it's up to you guys. But as long as state aid's involved, I have to follow the law.
All right.
All righty.
Yeah. This is just like coming out of the blue for me, because she told me she wanted nothing from me.
And I'm sure, and like I said, I'm sure she probably doesn't. And maybe she won't get anything from you. The state may confiscate all of this depending upon what state aid she's on.
So I'm paying for her state aid. So
you're paying for your child's state aid, not hers.
Okay. Yeah, because
yeah, I know.
Last thing I heard from her is that she wanted nothing to do with me, nothing with my kids.
And she probably still does not, nor does she probably want this. But again, this is mandated by the state of Michigan.
Since I have to mandate the support, how do I get to see my kids?
You may file appropriate motions. This order allows you to file to request mediation with her at the front of the court in Kent County. So this order actually opens a door for you over the next year to mediate it. If you can't mediate it, you may file a motion to get parenting time.
Okay, because I haven't seen my kids in 8 years, and I miss my kids. And I
again,
say my kids because
yeah, I
whether
know.
they're mine or
Whether
not,
they're New Year's or not, you were involved. Yes, I understand.
yeah, exactly.
All righty. In any event, good luck. Sorry about the botched marriage, but I guess maybe that's a good thing at this point in time. So, but good luck to you. And again, neither one of you brought this case. State of Michigan had to. If she ever gets
All
off
right,
state aid,
how do
that's
I
up to you two. How do you what?
how do I make payments?
The front of the court will automatically contact the state of California and arrange for that.
So
That's
it'd
why
be
you.
just
That's why you.
one-
Yeah, that's why you also have to keep the front of the court informed of any address changes. Okay.
Okay, because I'm
And
supposed to be,
any employer change. That way they know
okay,
what
'cause I'm
employer to
supposed to
contact.
be moving to Oklahoma,
Okay. Well, good luck with the move.
which
Stay
is-
safe.
I will.
All righty. Take care of yourself.
But all right,
We'll see you in the future over the parenting time
Thank you.
issues. Good luck with the move. All righty.
Well,
Motion
thank you, Your Honor.
granted.
We will be pursuing he's logged off.
Oh, you'll be pursuing
We'll be pursuing a paternity
UFSA.
action. So
Okay. Oh, on the other two. Yeah.
yes. Are we still? Has the case been adjourned?
No, I just ruled in your favor and I'm granting your motion. So
Thank you.
he just left. So
Thank you.
but
To
yeah, I
inform
had
the
no
court, the children were conceived in the state. Those two other children were conceived in the state of Michigan. So we will likely continue that paternity here. That paternity actually here, unless something changes or something gets brought up.
well, and
We
she
will
may
be back.
tell you somebody else that's the father too.
Or that as well. We will work on it.
I have no doubt. I figured once you put all that blah blah on the record, that's where you were headed with it. Alrighty, shall we do another case? Set for hearing at 10:30. The state of Michigan through the Kent County Prosecutor's Office has filed all the appropriate paperwork. I don't see a recommendation, Miss. Oh yeah, it's in here. Never mind.
Whoa.
I don't have a separate.
I about had a heart attack.
No, it's in the file. I don't have a separate judge's copy. So yeah, I did review it. Looks appropriate. You did do the deviation, correct?
I did, Your Honor. That is
Okay,
correct.
because that's what I'm
Originally,
missing.
It was $927
Right.
for two children.
But since the daycare was so expensive compared to
Yeah.
how much he pays, daycare is limited to $190 a month.
310 is the number that I gathered. He has a base
It
support.
should not be. Yeah.
Base
Oh
support
wait.
prior to the parental time offset is $630. Divide that
Okay.
by $315 on the nose, Your Honor.
Forgive me. I'm used to your cases having 0% parenting time and
That
his
is
130.
that's
So
understandable.
that does change things. All right. I was just doing with it as clean numbers. But in that case, it follows and comports with the court's rulings in the past and the child support guidelines of the state of Michigan. Your motion is granted.
Thank you, Your Honor. I appreciate it.
Michigan, because there is all right.
have to take the
State aid
DocuSign as well.
involved, and as such, the state mandates that a case be started, child support be set by law in accordance with the facts of the case, and the state will then confiscate whatever they wish to confiscate, depending upon what type of state aid is involved. So the mother may receive some part or none of the child support being ordered. The state will confiscate part of it. So I will let Ms. Smith-Lowe proceed on the state's motion. She represents the state of Michigan through the Kent County Prosecutor's Office. Once she has placed her motion on the record, I will ask for input from each of you. Ms. Smith-Lowe, you may proceed.
Thank you, Your Honor. This, as the court is aware, this case was filed on January 19, 2024. Service was proper on Mr. Villanueva on March 20th, 2024. He responded and answered the complaint on April 12th. And a pre-hearing conference was scheduled on May 15, 2024.
I'll be right back in there.
I spoke to both parties by phone on that day separately, and the calculation for one child was based upon Ms. Roblito's actual income of $16 an hour, 30 hours a week. 35 hours a week. And that was raised slightly in equity to Mr. Villanueva because he is working full time. She has 287 overnights and one other child, and also based upon his actual income of $19 an hour, $19.05 an hour, 40 hours a week with 78 overnights. 3 nights per week, every other week, and he has 2 other children. Mr. Villanueva indicated that he doesn't really object to paying child support, but he didn't agree at that time because he was in the process of filing a ROPA motion in Calhoun County for one of his other 2 children.
Okay, no problem. All right, Ms. Robledo, you're the plaintiff in this matter, even though you did not bring the case. What is your input?
What was said is I agree with the same thing.
Okay, Mr. Villanueva, any input from you, sir? Just about that moment, he freezes. Come on, Sergio, kick back in. You can do this. I know you can. Come on.
Hello?
Mr. Villanueva, okay, just as I asked for input, you blank out. What's going on?
What's going on? You can hear me now?
Yeah, what's your input, sir?
How much was it?
$424 a month, which comes out to $97.47 a week.
97. All right. That's what I got to pay her?
Yep. Well, or the state of Michigan, depending upon what state aid she's on. Like I indicated, we're here only because state aid's involved, and the state will confiscate the portion that they believe to reimburse them for the state aid that they pay for the child, and it would depend on what state aid she's on. So I can't even tell you how much they'll take.
Oh, so they might take more than $97?
No, they can't. No, they can't take any more than 97. That's the law says that it's got to be set by law. Once it's set, the state determines how much it takes as its cut of this, depending upon what state aid Ms. Robledo receives. But they can take no more than what is ordered. Or they adjust her what state aid she gets. They can do that too. Okay, any other questions?
No. Nope.
All righty, in that case, I'll grant the state's motion, and I wish you both well. Good luck on your revocation of paternity action in the other county, sir. Take care.
Thank you. Bye.
All right, bye. We'll get him, Miss Johnson. Don't worry. Next match set. He's trying. There, almost. Oop. There, he got it. Mr. Winters, welcome. How are you, sir?
I'm good. How are you?
Oh, it's been a morning. But in any event, at least you guys didn't have to be here since 8:30. Thank you for your patience. Sorry, we had a bunch of these. In any event, we are here in the matter of Johnson. We are here on a motion by the state of Michigan, not by either party. Neither one of you brought this case. The state of Michigan brought this case because state aid is involved. So the matter is brought to preserve the state aid for the children. The state mandates that child support be set by law, and then it confiscates part of the child support that's ordered to reimburse the state for what it pays on behalf of the child or children. So whatever this order is, Ms. Johnson, you probably won't receive it all. Mr. Winters, it'll be set by law. But I will let the state proceed with its motion, and I'll have input from both of you. Ms. Smith-Lowe, if you care to proceed, ma'am.
Thank you, Your Honor. As the court is aware, this case was filed on December 1st, 2023. Service was proper on Mr. Winters on February 14th, 2014, and he responded on March 8th, 2014, requesting genetic testing. The results of the testing indicate by scientific certainty that he is the biological father of the child.
I was going to say, there's a biological child involved. We know that, yes. That's no problem.
He's the biological father of the child, and a pre-hearing conference was scheduled on May 21st. I spoke with both parties separately. Mr. Winters indicates that he keeps the kids because she works third shift and has them most of the time. She says that he keeps the kids at her house and doesn't work. Mr. Winters told me that he works at Burger King and makes $15 an hour. I questioned whether or not this may need to be referred to in front of the court, but the calculation was based upon Ms. Johnson's actual income of $21 an hour, 40 hours a week with 209 overnights and one other minor child, and Mr. Winters' actual income of $15 an hour with 40 hours a week with 156 overnights, no other children. Birth costs of $66. Birth costs were reserved, and genetic test costs of $66 is being requested. The uninsured medical split is 54% plaintiff and 46% defendant. We're asking that the judgments be entered as proposed, Your Honor.
Thank you, Ms. Johnson. Any input?
Are you saying the amount of $144 a month?
Correct. That's correct. And again, you may receive some or none of it, depending upon what state aid you're on.
Yeah, that's based upon the overnights, his overnights being 156 overnights a year. And Ms. Johnson, you would be able to tell us best whether or not that's accurate.
I just want to make it clear.
Well, yes, sir.
Clear that when I said I didn't have a job, I haven't had a job since a month and a week right now. Jobless.
Okay, then I would have to impute you an income. Do you have some mental or physical disorder that prevents you from working?
No, I'm looking for a job.
Okay. Well, then I would impute you at about 32 hours a week at the $15 minimum wage. So it's going to be close to this one way or the other. They don't have a choice but to impute. Because you have an unexercised ability to earn income.
Your Honor, I may have interrupted Ms. Johnson. I was trying to clarify.
Yeah, that's okay. Mr. Winters interrupted all of us before you did. So I was trying to deal with his question so that he wouldn't keep interrupting. But Ms. Johnson, we were on you. So what is your...
So is that could that be changed or like in the future?
Yes, child support is changeable until the child turns 18 and is out of high school.
Okay.
Depending upon, suppose he gets a big job tomorrow or you lose your job completely. It'll depend. Gaining new employment or better employment or losing your job through no fault of your own is a change of circumstance. Otherwise, child support can be reviewed every 3 years just in time. They consider 3 years a change of circumstance. Other than that, a change of circumstance is a change of jobs, a new job, or a loss of a job through no fault of your own. Okay. Mr. Winters, now let's go with you. Now your turn. No problem. I was going to give you your shot, so don't worry about it. All right, let's start. What questions do you have, sir?
I just want to clarify, I didn't have a job like a month.
Right.
And like a week. And what do you mean by impute? You said that word.
Imputation means that if you have a capacity to work, we're going to hold you to an income. And that's the law in the state of Michigan, unless you have some mental disability or physical disability that would prevent you from working. Because the law is set up to prevent things like, oh, gee, we filed a child support order and you quit your job and therefore it's going to be set at zero. No, it won't be. It will be held to a job that you are capable of earning.
Okay.
All right. That's the law in the state of Michigan.
All
So yeah, typically we do between 32 to 35 hours at minimum wage, which is going to be pretty close to what this is. So I'm not sure there's going to be any changes. So I'm probably just going to enter this as it is and please get a job and then notify the front of the court who that employer is.
All right. What do you
Alrighty.
mean by on the hours? So I have another question. My bad. What do you mean by 30 hours? What do you mean by that?
By the what? By what? I generally don't hold you. I generally don't hold you to 40 hours, but I hold you to about 32 to 36 hours because that's within the range of full-time work, which is what I would have to hold you to. But again, at this wage, at this calculation, mathematically, that won't make any difference. So I would enter the order as the Kent County Prosecutor's Office has drafted it.
Okay. Okay.
All right, because we're talking maybe a $5 a week difference potentially. Okay, because you're right there anyway. So because you were earning minimum wage, so that's where I'm holding you to. And then find a job and then notify the front of the court where that employer is. Okay.
Okay.
All righty. So I will enter the Kent County Prosecutor's motion and grant the state's motion. All right. Have a good afternoon, everyone. Take care. Stay safe.
Thank you.
Thank you.
All right. Next.
I decided
Take care.
I decided you needed to be busy today.
That's quite all right. You guys brought much more than normal, but that's okay.
Yeah, more than normal. I think
as long as we get them done, that's all.
Because of summer schedule and people are going to be out and, you know.
Hey, it is what it is. I do what I'm told. I don't get to choose how many motions I hear. Helen, today I only had like 25, and I still remember years when I used to have 30 to 45 of them. So, all righty, who's next, Miss LeVay?
Let's do Dobbs versus Westerfield.
I can't hear you. You have to unmute. Now I should be able to hear you. Say something.
I can hear you.
Yeah, there we go. And I can hear you. Perfect. Let's go on the record in the matter of Dobbs versus Westerfield. I'll note that Ms. Dobbs is not present. Mr. Westerfield is present. This matter was set for hearing at 10:30. It's now 11:26. Sorry, sir, we had a bunch of them. But at this point in time, to inform you, Mr. Westerfield, we are here on a motion by the state of Michigan through the Kent County Prosecutor's Office. Neither party brought this case. The case was brought by the state of Michigan because state aid is involved. When state aid is involved in a case, the state mandates the child support be ordered in accordance with the law, and then the state of Michigan confiscates portions of it to reimburse the state for what they pay on behalf of the child. So what I will do is I will let the Ms. Smith-Lowe present the state's motion through the Kent County Prosecutor's Office, then I'll ask for any input from you, sir. So Ms. Smith-Lowe, if you care to proceed.
Thank you, Your Honor. As the court is aware, this case was filed on September 7th, 2023. Service was proper on Mr. Westerfield on September 14th, 2023, and he responded requesting a genetic testing. And then there was a little complications back and forth. It's been going on for a while because he then decided that he didn't want genetic testing, but we had an order in place. And so we had to make sure that his rights were preserved. And the court wanted to make sure that that the judge wanted to make sure that she heard from him that he did not want genetic testing. And then that order was set aside. Then a pre-hearing conference was scheduled on May 15, 2024. And actually the parties agreed to the proposed judgments. Ms. Dobbs, a letter was sent to Ms. Dobbs to have her sign the judgments. They were returned signed. Actually, the letter requested that she arrange for Mr. Westerfield to sign the documents, and the documents were returned unsigned. So I scheduled this hearing because the deadline on the case was approaching and actually has passed.
All right. In that case, Mr. Westerfield, any input? Sounds like everybody was in agreement on this one. So
I can say for the record, Your Honor, what the actual calculation was based upon if you want to make a clearer record.
Well, let's see what he has. If there was agreement, if we may need to do that yet. But Mr. Westerfield, what's your input?
I don't have any input. We did have an agreement already.
Okay, no problem. Yeah, this is less than $100 a week. So in that case, since there was an agreement, it just wasn't signed by the parties and she's not present, I'll go ahead and grant the state's motion. And Mr. Westerfield, any questions?
Yeah, the only problem that I have right now, Your Honor, is that I'm currently homeless.
Oh, okay.
Sorry to hear that. And I'm having trouble finding a job. I also don't even have any transportation. I'm actually at an interview where I was, but I'm still here waiting on my ride. I just had an interview today, but unfortunately, I wasn't able to get the job again.
Okay,
and that's what I kind of been going through.
Keep trying and keep the front of the court informed. They may at some point look at you and go, we're going to hold it in abeyance because we're not going to keep going after you if you have no job, but they may be able to do something to assist you. So keep the front of the court informed and let them know that you're applying for jobs and show them what jobs you've applied for and show them the disqualifications.
Okay, thank you.
You may have just triggered some other hoop, but normally we hold an income to you. Especially if you've had an income in the past. Like I just had a case that he had a good income and then all of a sudden he seemed to have quit that job 8 weeks after we filed the state filed its ask for child support. But being homeless and looking for a job is a completely different issue. But right now, I would still have to hold you to the income that we've held you to because it's minimum wage. And again, there are things that the front of the court can assist you with, especially if you're homeless. All right.
Okay, thank you.
You have a good morning. Take care of yourself. Stay healthy and stay safe.
So I just rent. Is there someone specific that I can reach out to at the front of the court?
No, just the front of the court in general.
Okay.
They will assign you a worker.
Okay, thank you.
All right.
As soon as the friend of the court receives this judgment from the court after today, they will reach out to you regarding and so they'll send you information. So they don't have it yet, but they will have it shortly.
Okay, how long do you think that normally takes?
Typically within a week or so.
Okay.
Yep, and if you get on state aid, we've got other issues. But Miss Smithlow, I'm looking for the start date on this. Why don't we?
Oh,
I don't see a start date on this.
I have an effective date of July 1st.
Okay, 2024.
24.
All right, then that's when it will be the effective date. That way it doesn't start. We don't get an arrearage. All right, have a good morning. Thank you. Take care, Mr. Westerfield. All right, next.
Letter Nurel, sorry for butchering that, versus Sanders.
Okay, listen carefully. All right, ready?
I probably won't be trying to say that.
Miss Letourneau? Kathy, can you hear us? Miss Letourneau, if you could unmute, please.
Okay, can you hear me now?
Yes, welcome.
Okay, good morning.
Good morning. All righty. And we are here in the matter of Letourneau versus Sanders. Thank you for your patience, ma'am. At this point in time, I will note that Mr. Sanders is not present. This matter was set for hearing at 10:30. It's now 11:33. We are here on a motion by the state of Michigan. And I believe this was brought by the probate court, Ms. Smithlow, or is it because state aid's involved?
No,
I'm asking the prosecutor. I'm asking the prosecutor, Ms. Letourneau.
Oh.
Yes, there is assistance, Your Honor.
Okay, because there are a couple ways to bring this, Ms. Letourneau. One is because when state aid's involved, the state mandates child support be set by law, because they will confiscate part of the child support to reimburse the state for what they pay on behalf of the child. So it depends on what state aid's involved. You may or may not. You won't get all of what's about to be ordered. Some of it's going to be confiscated by the state because of state aid. That's why I wanted to make that warning.
Okay.
If it was sent purely by the probate court and state aid's not involved, different explanation. Okay. All right. So the state brought this motion due to state aid, and the state is represented by Ms. Smithlow through the Kent County Prosecutor's Office. So I'll let her proceed with the motion, and then I'll ask for any